21 years into our nascent democracy, and South Africa is absolutely no stranger to commissions. But this one, the Madlanga Commission in particular, is one that hums differently. It began with a press conference that sounded like a declaration of war, a fight of some sort. The Madlanga Commission is now in full swing. What started as whispers in police corridors has become a roar shaking the highest officers in the land. And yet, amid the swirl of syndicates, power play, suspensions, and arrests, one question remains. What will this commission deliver? What is the promise it holds for the public? With truth and teeth, or is it performances in robes? We'll break down where the inquiry stands today and what we have learned thus far and what the coming week may hold, from testimony fireworks to legal turning points. But to make sense of the smoke and signals and legalese, we need someone who speaks fluent commission. And today we look to the legal eyes of Bophelo Sileka, who is a legal expert, to help us comb through this. Bophelo, welcome to the show. Thank you so much for joining us. Really do appreciate it. Now, we're into the second week of the commission and the work that the commission will be doing. But it now raises a few legal questions that I think, particularly pertaining to evidence, that I think you and I should be able to talk through. General Mkhwanazi had mentioned the names of several people, some more interesting than others. And some of them being organizations who have now come forward saying that they want to appear before the commission to clear up their names. One such organization is Richards Bay Minerals, where Mkhwanazi extensively spoke about a deployment of detectives as well as technical response team members during a time where there was a high rate of murders pertaining to the business around the Richards Bay Minerals mine. The company has now come forward and said they want to appear before the commission to clear the names. Interestingly, though, the commission may never call upon them. What happens in such an instance where you have a commission with a finite amount of time, but many people might want to say, hey, my name was mentioned. I don't quite like what was said. I want to come forward and clear my name. Will the commission afford everybody the space who would like to come forward?
Well, thank you. Not necessarily. What we need to also understand is testimony in a commission of inquiry can be classified as compelled evidence, in that a witness cannot refuse to answer, or perhaps even to a certain extent wish to appear, even though the commission would have concluded its business. And by that I mean, under Section 35 of the Constitution, and with what you've just mentioned now, accused persons or named persons in commission proceedings have a right to, not incriminate themselves, or rather not to be compelled to give self-incriminating evidence in proceedings such as these. But what this means is that a commission cannot be used directly as a witness in a criminal trial, should the prosecuting authority prefer criminal charges. But if testimony reveals possible conduct, the commission may refer the matter to law enforcement, which ours is the National Prosecuting Authority, and the NPA must then independently investigate, gather admissible evidence, and build a prosecutable case. This principle was clarified and applied during the Zondo Commission, where the findings were forwarded to the NPA as an investigative lead rather than ready-made prosecutions.
May the commission, in its final recommendations, make recommendations for the further pursuances of investigations and or prosecutions against an entity or a person if they've never given that person an opportunity to appear before the commission? That is to say, consider the following scenario. Let's say, for instance, the commission says, look, this Richards Bay mineral thing is interesting, but it's not the most important priority for us at this moment, given our resources, our time, and our terms of reference. But we do think that there's something to be looked into as far as that is concerned. Could they then insert into the final report and say, hey, we are instructing the NPA to further investigate or to consider prosecutions against these organizations? Would that be fair if they never gave that organization an opportunity to substantively respond to any and all of the things said about it, whether allegations or whether something that is short of an allegation but not necessarily favorable before the commission?
Okay, so I think let's look at it this way. Commissions of inquiry in South Africa are investigative mechanisms and not courts of law. And you'd know that their constitutional foundation lies in Section 84, 2F of the Constitution. But what's most important is that this specific commission, the Madlanga Commission, is an investigative mechanism of enormous public importance, in that its value will not lie in the spectacle of the hearings or the drama of the testimony. Its true worth will be measured in three things: whether it exposes systematic truths, whether its findings withstand scrutiny, and most importantly, whether its recommendations are acted upon. You and I will know that commissions expose, but they do not convict. So testimony informs, but it does not amount to fact until tested. And accountability will only reveal or be real in law enforcement and government through follow through. So without that, we risk mistaking theatre for justice, and with it, we strengthen democracy and the rule of law by focusing on what the true mechanisms are for these bodies.
Given the limited time that the Commission has, it's supposed to produce an interim report after 3 months and a final report after 6 months. It may well be that the Commission can't have testimony, oral testimony from everybody that it needs evidence or responses from. How does the Commission treat written evidence? Can people make a written submission and or request to make a written submission even if they never appear for oral testimony before the Commission? Is that permissible within the Commissions Act?
So what the Commission then seeks to do is, of course, grounded in the Commissions Act, would, one, receive oral evidence, such as testimonies of witnesses that appear before the Commission, but it does not limit its submissions of evidence to oral. So an individual may say, I would want to contribute whatever it is, information that I hold that may be beneficial in the scope of work of the Commission. And this would be facilitated through the appointed evidence leaders, where the submissions can be made and they can form part of the actual recommendation of the Commission at the end of its term.
Yeah, let's talk about cross-examination. That certainly will happen. We've already gotten an indication from the Commission that General Mkhwanazi, who is seemingly the principal witness and evidence bearer, will be returning to the Commission at a later stage. And that might be for the purposes of further clarification, further evidence, but potentially cross-examination by those he had directly implicated in the Commission. Again, given the short amount of time that the Commission will exist for, are people guaranteed the right to cross-examine if they've been implicated by a witness before the Commission?
Well, cross-examination in this instance would only serve to strengthen the burden of proof, the evidentiary rules of testimony that's given in a commission. So in order to test the right of any testimony that is submitted or said in any commission, remember, what is said before a commission is not the gospel truth. There must still be a guardrail of ensuring that the evidence will carry burden.
Yep.
So we need to be able to know that witness that goes on a commission, the evidence that they would adduce or a testimony in the commission is in fact factual and is in fact corroborated through the evidentiary rules in the Criminal Procedure Act. So cross-examination then plays a very much important role in this instance, to say, this is what you've said, now let's fact check, let's cross-examine. Let's tick the boxes to ensure that what you've given this commission holds water truly.
Yeah. And just lastly, we've heard from General Mkhwanazi that there's quite a bit of evidence that will need to be accessed by the Commission to corroborate some of the claims you've made. But a great deal of some of those evidence, particularly from crime intelligence, is classified evidence. The Commission would need to apply for the declassification of that evidence, at least to access it. Does the declassification of evidence make it publicly available, that is to say a public record? And or can the Commission ask to have a judicial peek, so to speak, of certain classified information and or documents within crime intelligence for the purposes of corroboration? How do they treat the sensitivity and complexity, or how will they and should they treat the sensitivity and complexity of classified evidence?
Certainly the latter will apply in this instance, where the Commission would have to make representations or petitions for certain information or evidence be made available to itself, and would have to then do a balance check to say the evidentiary material we in the course of work of the commission must, of course, still be within the guidance of the law. And in this instance,
oh, Boipelo, it seems like we have lost you there.
Of clearances that need to kick in.
Yeah, Boipelo, it seems like our line is not particularly stable, but I think we got the gist of that point there. Fortunately, that's all we have the time for. Thank you so much for your time and your insights. Really do appreciate it. Boipelo Sileka is an attorney.